So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about a Supreme Court ruling that unions can be sued for strike damage that happens to company property. And that seems like something you would expect, but it hasn't always been that case. This article is from Fiona Ong. She's a favorite of this channel. You can take a look at the article linked down below if you want to learn more. Glacier Northwest versus the International Brotherhood of Teamsters. So the International Brotherhood of Teamsters is a fairly large union, most famous for Jimmy Hoffa, although they're a lot deeper and a lot bigger than that. And after their collective bargaining agreement, so after their contract expired, the union looked to stop work and go on strike. And it knew that the company was preparing to deliver a large a bit of concrete to the employee. And this article doesn't say exactly how much concrete was going to the customers, but it was loaded onto trucks, and then the truck drivers left the facility, but then never actually took it to the customers. As a result, they tried to save the trucks and the concrete. I mean, I don't think concrete's all that expensive. I'm sure that the cost here really is the damage to the trucks, but all of it was lost. So the company sued, and the union said, no, you can't. The National Labor Relations Act overrides state claims. And ultimately, this is concerted activity under the National Labor Relations Act, specifically Section 7, which you've seen quite a bit about that in the last few videos. And so as a result, the state of Washington couldn't hold the Teamsters accountable for doing this. And Washington State agreed, saying the court at Washington State agreed, saying that, ultimately it was a loss incidental to a strike and protected by federal law, which is wild. The idea that you can just simply destroy property and the National Labor Relations Act would override you is insane, and it's very frustrating. And I think that what's going to happen is you've seen, and this is probably true for a lot of different laws, but you've seen the Supreme Court put more power in the hands of the employers over the last few years, specifically since the Trump presidency. But it's coming into competition with the National Labor Relations Board and subsequently the National Labor Relations Act. And ultimately, the Supreme Court has a lot more power than the board, and that's what we see here. The Supreme Court disagreed with Washington State Court and said that the sudden cessation of work placed the company's property in foreseeable and imminent danger, in that the concrete was destroyed and the risk of harm to the trucks was both foreseeable and dangerous. So they could have controlled it, they just didn't want to, and they failed to take reasonable precautions. And so they rejected the argument that the National Labor Relations Act protections should be interpreted generously, noting that the right to strike is limited by the reasonable precautions test, and that ultimately that the National Labor Relations Board's precedent that protects strikers' conduct, even when there is a risk that perishable goods would spoil, they have that duty. So I think that that's interesting. I think that this reversal of a long-standing practice and what the Supreme Court has said is a really interesting situation. Again, I think that there are a lot more protections out here that the National Labor Relations Board are encouraging people, but but the Supreme Court would ultimately find a violation. And for example, the National Labor Relations Board recently uphold a longstanding tradition of protecting racist language under the guise of strike activity, under the guise of Section 7 rights, right? They recently protected racist language and said that it was acceptable in the course of Section 7 activity. I don't think that the Supreme Court will find that, and I think that they'll find that it violates several causes in the future, and so a longstanding act of this National Labor Relations Board may ultimately, many of its laws may ultimately be overturned by the Supreme Court, or regulations and laws. So it's a very interesting thing. The Supreme Court further observed that even though the National Labor Relations Act does not require timing the strike to minimize economic harm, because of course strikes are best done when there is economic harm, they are required to look at relevant considerations, evaluating whether or not the strikers took reasonable precautions, and so the fact that the drivers returned the trucks to the facility and left it rotating did not establish, left the trucks rotating, did not establish reasonable precautions at all. And ultimately, just because they refrained from stealing from an employer's vehicle doesn't demonstrate that they took reasonable precautions. What do you think? The Supreme Court found that because the union took affirmative steps to endanger Glacier's property rather than reasonable precautions to mitigate that risk, the National Labor Relations Act does not protect its conduct. And of course, I am not a lawyer. I'm not even playing one on TV, but I want to know what you think. If there are any lawyers, specifically employment lawyers, leave a comment down below, and we'll see you on the next video. Bye, guys.